Good afternoon, everyone. The next statement is going to be made by Mr. James Agaros, Queen's Counsel, on behalf of the TMO. Mr. Agaros, I see you on my screen. I hope you can see us, can you? And can you hear us?
I can indeed.
Oh, good. And
I can, thank you very much.
And we can hear you, that's excellent. Right, well then, if you're ready to make your closing statement, please go ahead.
Yes, well, good afternoon, Mr. Chairman, and good afternoon, members of the panel. At the outset of these closing submissions for modules 1 and 2 of phase 2, the TMO wishes to reiterate that its deepest sympathies and condolences remain with the bereaved survivors and residents, and it reaffirms its commitment to supporting the inquiry in its valuable work. So between September 2020 and March 2021, you heard evidence from numerous individuals from a range of entities in relation to phase 2 modules 1 and 2. And while the issues in modules 1 and 2 are distinct, there is a significant overlap, not least because the matters investigated in module 2 resonate in many aspects of the matters considered in module 1. Module 1 was concerned with the design, development and refurbishment of Grenfell Tower that took place between 2012 and 2016. It focused on various issues, including but not limited to the decision to refurbish Grenfell Tower, the appointment of various pre-contract professionals by the TMO, and RBKC planning and building control. So module 2 is divided into 2 parts. Part 1 investigated the way in which the primary materials used on the Grenfell Tower refurbishment were manufactured, tested and sold, and this included a consideration of the wording of the relevant certificates, whether the fire performance of the materials was presented in a fair and transparent manner in marketing and technical literature, and what the different manufacturers knew about the use of their products on Grenfell Tower. Part 2 then examined the role of the testing and certification bodies and the extent to which they audited the manufacturers and how test results were interpreted by the relevant bodies. So the TMO witnesses did not participate in module 2, but the evidence before the inquiry has been deeply troubling, and it's right that the TMO comments on it, especially considering your conclusion in the phase 1 report, and I quote from that, the principal reason why the flames spread so rapidly up the building was the presence of the aluminium composite material, ACM panels, with polyethylene cores, which acted as a source of fuel for the growing fire, and the presence of the PIR and phenolic foam insulation boards behind the ACM panels, and perhaps the EPDM membrane and the aluglaze window infill panels contributed to the rate and extent of vertical flame spread. The importance of these findings cannot be overstated when considering that the TMO's fire safety strategy, as is common for buildings of this nature, was based upon compartmentation and 27 active and passive fire safety measures to support the stay put policy, which, as Professor Torero said, was based around the concept of no external spread of the fire. The submitted inquiry should also keep in mind, sir, the active and passive fire measures at Grenfell Tower were not designed to perform in the extraordinary circumstances which arose or where non-compliant fire propagating products were installed. In summary, the TMO submits that legitimately and necessarily delegated responsibility for important elements of design, materials selection and construction to qualified professional bodies through properly structured contractual arrangements. The TMO submits so that for a non-construction professional to delegate in appropriate circumstances is necessary and legitimate, and it should not be viewed as dodging or abrogating responsibility or buck passing. So the evidence heard in Module 1 demonstrates that several professional teams who contracted with the TMO and between themselves failed to select and use products which were compliant with prevailing standards. Some of the causes of these failures were uncovered in Module 2, which disclosed that the marketing and sale of those products was often not driven by safety considerations. And so the TMO wishes to make it clear that if it had known about the combustible nature of the products used in the refurbishment and their ability to support the surface spread of fire, it certainly would not have permitted their use. As has been said before by the TMO invites the inquiry to place its actions in context, i.e. to consider whether the way in which it acted during the procurement, design and construction phases was substantially different from any other social housing management organisation, especially in the light of knowledge in the housing sector of cladding danger at the time. So we, on behalf of the TMO, note that while the inquiry has obtained expert evidence that addresses the performance of many corporate bodies and professions, it has not heard evidence from any individual who can speak with authority about how a body like the TMO may have been expected to act when fulfilling the role of CDM client in major public works. So in making this assessment, the TMO points to the fact that following the fire at Grenfell Tower, over 2,000 buildings, or something like up to 1 million homes, have been found to be clad in the same or similar materials as were used at Grenfell Tower. For each, there would have been a client, and in no case, apparently, was the client able to prevent unsafe cladding being erected. So the TMO submissions on Module 2 matters will be taken out of turn. They'll be addressed at the beginning of these submissions, as the evidence before the inquiry has disclosed numerous disturbing abuses of the classification and certification system, which has caused and underpinned the national cladding crisis and led to a belief from many of those involved in the project that the products used on Grenfell Tower were safe for use. Turning now to the certification and classification of materials used. So as the inquiry knows, the primary materials used in Grenfell Tower and considered in Module 2 were Rainabond PE 55 rain screen panels, manufactured and sold by Arconic, RS 5000 insulation boards, manufactured and sold by Celotex, Kingspan Cool Therm K15 insulation boards, manufactured and sold by Kingspan, window infill panels manufactured by Aluglaze, and Lamathern cavity barriers manufactured and sold by Siderize. Part 2 of Module 2 examined the role of the BRE, the BBA and the LBC in the wording of certificates and the testing, auditing and monitoring of manufacturers and their products. Dealing first with the Rainabond 55 PE rain screen panel cassette system, which was manufactured by Arconic. This was the most prevalent cladding used on Grenfell Tower. So you heard evidence that the system was tested in 2005, but the test was actually stopped after 850 seconds, with the results of the test being recorded as not usable, but give an idea of the fire behavior of the product. The system obtained only a Class E rating in 2005, and the same rating when tested again in 2011, 2014, and 2015. To be used on buildings over 18 metres, in accordance with ADB, products had to obtain either a European Class B or national Class 0 rating. With no Class B or Class 0 rating, the product should never have been considered for use or used at Grenfell Tower. Even though it had not achieved a national Class 0 certification in any test, the BBA issued a certificate which seemed to represent that it was indeed Class 0, which certificate witnesses have said was misleading and factually incorrect. So Mr. Jonathan Sekula, one of your experts, said that he would expect a contractor to accept a BBA certification, and it was accepted in evidence by Arconic that anyone reading the certificate would have been misled. And so this is particularly troubling, as Arconic was aware that the cassette system was to be used on Grenfell Tower. RS 5000 insulation boards. RS 5000 insulation boards, which you found, sir, in your phase 1 report, more likely than not, contributed to the rate and extent of vertical flame spread, were manufactured and sold by Celotex and used on Grenfell Tower. The inquiry heard evidence that the RS 5000 insulation test, which was conducted in May 2014, was rigged following an earlier failed test, with 2 magnesium oxide boards being added to improve its chances of passing the fire test. Not only were 2 magnesium boards added, but Celotex also used cement panels to conceal their presence from onlookers or later in photographs. After the test was conducted, the magnesium oxide boards were not referenced in either Celotex's marketing literature or in the BRE report. And the BRE accepted that in failing to note the magnesium oxide on the test rig, it made a fundamental omission, and that Celotex may have made a concerted effort to hide it. So even more concerningly, possibly, ex-employees of Celotex told the inquiry that a BRE employee was aware of the presence of magnesium oxide boards. Unsurprisingly, Celotex accepted that its marketing and technical literature was thoroughly misleading, and that the omissions and misdescriptions were entirely deliberate. It also accepted that the system which had passed the test would not have been commercially viable if the test had been done correctly. And so, of course, while ultimately a matter for you and for the inquiry, there appears to be a strong cynical and manipulative element to Celotex's conduct, which had little or nothing to do with the promotion of safety. Kingspan Cooltherm K15 insulation boards. Cooltherm K15 insulation boards manufactured and sold by Kingspan were used on Grenfell Tower. Again, the inquiry heard evidence of misrepresentation by Kingspan and malpractice potentially within the BBA. Kingspan tested the K15 insulation in 2005 in a version that passed the fire test, but later changed its chemical composition in a way that caused it to perform very differently in a fire situation than before. In fact, in a test in 2007, the new composition burnt ferociously and had to be extinguished before it set fire to the laboratory. And unsurprisingly, therefore, it did not achieve the criteria of BR135. Despite the 2007 failure, Kingspan continued to market the product based on the 2005 fire test results, which it accepted in oral evidence amounted to deliberately misleading the customer. When in 2008, Boehmer and Kirkland, another contractor, specifically highlighted concerns with K15 to Kingspan, pointing out that the BRE test, which informed the marketing material, did not relate to the product it was supplying, and suggesting strongly that Kingspan clarify how the material was suitable for use, instead of addressing the concerns raised, Kingspan's internal documents demonstrated a cynical disregard for them. One manager wrote, "I think Boehmer and Kirkland are getting me confused with someone who gives a damn. And also, I'm trying to think a way out of this one. Imagine a fire running up this tower. Any ideas?" It's also alarming that a certificate was issued by the BBA in 2008, which classified K15 as Class 0, stating that the product will not contribute to the development stages of a fire or present a smoke or toxic hazard, when it was neither non-combustible nor a material of limited combustibility. Unsurprisingly, possibly, sir, the BBA accepted this was a very basic failure of due diligence. And further, in 2010, the certificate was revised to say that K15 could be used in accordance with paragraph 12.7 of ADB. The BBA said this was a human error, accepting this, the resulting certificate was capable of misinterpretation. So again, of course, it's a matter for you, but the TMO would say, in conclusion, in relation to these matters, that considering the many abuses of the regulatory system and how easily this occurred, and indeed the nationwide crisis it has played a part in causing, the inquiry should consider whether the certification system is fit for purpose. That so many dangerous products were certified and marketed as suitable for use in safety critical situations in high-rise social housing is deeply troubling. So now turning to Module 1 matters, including procurement some cost issues, and the question of pre and post contract appointments by the TMO and where design responsibility lay. The circumstances in which the decision to refurbish Grenfell Tower, including the source of funds and the decision to deploy them at Grenfell Tower, have been explored in depth, and so we do not intend to revisit them in any detail here. Suffice it to say that the motives were undoubtedly good and largely connected with improving thermal efficiency and domestic and shared amenities. And so it may be observed that it seems highly unlikely that any other local authority other than RBKC would have been able to spend a similar amount of money on the refurbishment and renovation of a single block of social housing, either then or now. So you know that the TMO was a not-for-profit organisation funded by public monies, and therefore it had an obligation to secure value for money in procurement. And so we submit that this should be kept in mind when the inquiry considers the question of tender bids, cost savings, and value engineering. Artelia's pre-tender estimate was just over 10 million. Ryden's bid came in at 9.249 million, Durkan's at 9.94 million, and Mullally's at 10.48 million. The average, therefore, was circa 9.8 million. Thus, while Ryden's overall bid was the lowest, indeed some 700,000 lower than the next lowest bid, this rightly provoked a question at a TMO board as to why this was. But so it's also worthwhile considering that Ryden's bid on the tender for the external facade was 3.8 million, whereas other contractors put in estimates of between 3.6 million and 4.1 million. Thus, Ryden's bid for the external facade was certainly not the cheapest. And so, as the inquiry knows, price was not the sole determining factor. Rather, it was 40% of the evaluation. The overall quality of the bid was 55%, i.e. the majority, and the interview was 5%. And Ryden scored highly in these latter two categories also. So as the inquiry is aware, Artelia was deeply involved in the assessment of the tender and would have been expected to comment or demur if there were any areas that were underpriced in Ryden's bid. And since they did not, the assumption was that Ryden's bid was realistic. So dealing now with value engineering as a concept and a discrete issue, rightly concern has been expressed about the concept and application of value engineering in the context of the refurbishment. It's been confirmed by several witnesses that value engineering, which may be defined as a process of trying to find more cost-effective ways of achieving the same outcome or achieving a better outcome for the same cost, is common in construction projects, as well indeed as in other industries such as the aviation industry, where safety standards are very high. Thus, it should not be assumed that value engineering involves the inevitable sacrifice of safety for costs. And the TMO would submit there's no sound basis for saying that this occurred during the Grenfell Tower refurbishment. Paul Hyatt, your architectural expert, was asked about value engineering, and he said that many design and build contractors are highly competent and highly responsible and will interrogate a design with great effect and find less expensive but not worse ways of doing something. So one discrete topic which we appreciate you will deal with is what's been referred to as the offline meeting between Peter Madison and Ryden. And can I deal with that now, albeit briefly? While it's right that the inquiry scrutinised this in many searching questions by Mr. Millett, we say on behalf of the TMO that you may conclude that although in hindsight the meeting was probably unwise, by the time it occurred, Ryden had already been identified as the preferred bidder through both price and quality. And as a company which had already completed several overcladding projects of this type, it was certainly not an inappropriate choice. While again, it's right to say that Ryden was asked to carry out some value engineering, it's likely that any successful tenderer would have been required to do the same thing. And there was nothing irregular about value engineering in the context of a refurbishment funded by public money costing around £10 million. Can I now turn to some cost issues in relation to the selection of materials used at Grenfell Tower, and in particular in relation to the selection of cladding materials? So it was clear from an early stage to Ryden that ACM was cheaper than zinc cladding, and it estimated that using ACM in lieu of zinc would lead to a saving of just under £300,000. Harley negotiated on cladding prices with Ryden and offered them a saving of approximately £419,000 for ACM cassette and approximately £576,000 for face-fixed cladding. In fact, sir, and it may be a factor which the inquiry takes into account, Harley's price included a costing error, which left them some £212,000 out of pocket. And cynically, the inquiry may find both Harley and Ryden agree that the TMO could in some way absorb the cost of Harley's error, and only £376,000 of the £576,000 saving was in fact passed on to the TMO. While the cheaper ACM cladding was chosen in preference to zinc, none of the TMO's professional advisors seem to appreciate that this may affect fire performance or safety, and certainly none advised the TMO that there was any safety disbenefit. In evidence, Peter Madison denied that the TMO was looking for the cheapest cladding. He said that, in discussions with Studio E, he was looking for something that would secure planning permission and would meet all pertinent safety regulations. Claire Williams, in turn, said that when the cladding was discussed, it was always referred to as Class 0, and no contractor ever suggested that one type was inferior or better quality than another. And so also any suggestion that TMO selected Rainabond PE rather than Rainabond FR, i.e. fire retardant, for cost reasons is wrong, as the TMO was never informed that Rainabond was available in a fire retardant core as well as a PE core. And so it's a point which the inquiry may wish to take into account. But additionally, the fact that the more expensive cassette was used in preference to the face-fixed product indicates that cost was not the sole or overwhelming driver for the TMO. Even if, with the benefit of hindsight, the TMO had asked further questions about the pros and cons of ACM over zinc cladding, it may still have been chosen given its common use in so many construction projects at that time, and indeed the evidence which the inquiry heard about incorrect certification in Module 2. In summary, the TMO says that the inquiry may rightly conclude that the TMO's aim was to find a cost-effective cladding, but not necessarily the cheapest cladding, and certainly not a cladding where safety was sacrificed for cost. Had the TMO been told by any of its professional advisors that the cladding was unsuitable or even dangerous, it would undoubtedly have made a different decision. Regarding insulation, and to take this briefly, the inquiry heard evidence that the products used on the refurbishment product were discounted ones and were different from those contained in the MBS specification. And so even though there was a requirement for any changes to the MBS specification to be approved by the TMO in writing, the TMO, was never informed that Celotex RS5000 had been substituted for Celotex FR5000, or indeed that Kingspan K15 had been used. And so there was certainly no discussion of the insulation material during the value engineering exercise. So can I now turn to TMO's role and various aspects of it?
Mr. Agros, before you do, can I just say that from time to time you're in danger of slipping off, not off entirely, but slipping down at the bottom of our screens. I don't know.
Oh, I'm so sorry.
No, that's right. It hasn't prevented us from understanding what you're saying.
Oh, I see.
Oh, that is a bit better. Yes.
Is that better? I'm sorry. I may have adjusted my screen
No, don't worry.
Ill-advisedly. I apologise for that.
You didn't disappear too much, but I think that's better.
Okay, I'm glad for that. You can still hear me, sir.
Oh, yes, thank you.
Yes, thank you. So the TMO was the client for this design and build project. And the role of a client in a CDM project is defined within the regulations, i.e. the CDM regulations and related guidance and ACOP. And so these specifically envisage that a client may not have construction experience and is entitled to rely on its professional appointees. In the pre-contract phase, the TMO engaged a professional team, which consisted of Artelia, Studio E and others, to design the project brief and to plan and manage the pre-construction phase on its behalf. Artelia was engaged throughout the project, and in the pre-contract phase, it advised the TMO about appointing a professional team of designers and contractors to turn the brief into a realizable design, as well as administering, advising on the procurement and value engineering exercises. So it had a duty to advise the TMO if any appointees made by it were lacking or unsuitable. The post-contract phase commenced in October 2014, when Ryden was appointed as principal contractor under the JCT design and build contract. During the post-contract phase, Artelia was the TMO's employer's agent and contract administrator and was responsible for monitoring progress of the contract. It remained in the important role of CDM coordinator, referred to as CDMC, throughout the project, at least until October 2015, when CDM 2007 was superseded by CDM 2015. But so it's notable that by this time, i.e. the introduction of CDM 2015, most of the important design decisions had already been taken. So it's been suggested, and by Artelia in particular, the TMO has underplayed its role in decision-making and underplayed its responsibility for signing off on designs. So the TMO does not accept that it's underplayed its role. It acknowledges its role in some design decisions, but it's only fair to say that these were in narrow and limited circumstances. As a non-specialist client, it did not have a duty actively to scrutinize designers or their design decisions at every turn. Moreover, it had a legitimate expectation that the companies engaged would meet the terms of their contracts regarding their own design and safety responsibilities. So the TMO has been described as an educated or informed client on a number of occasions, in fact, in part because it seems Mark Anderson and David Gibson were qualified architects. It's been suggested that TMO should have questioned Studio E and other professional bodies further, including about design decisions made. In fact, Mr. Anderson had not worked in practice as an architect for many years, and in any event had moved on before the detailed design work and refurbishment began. Although Mr. Gibson was a qualified architect, he was not employed as such within the TMO, and he had not worked as an architect since 1991 and had never been involved in any overcladding project before. Neither he nor Claire Williams had any technical expertise in relation to the refurbishment. So overall, in this context, the TMO would say that it was entitled to rely on the expertise within its project team of consultants and contractors, and the contractual and legal framework regarding selection of materials, including cladding and insulation, and compliance with the prevailing legislation, regulations, and guidance. So one of the discrete issues which was addressed in evidence in Module 1 was the question of project manager. And the question was whether a scheme project manager was necessary and should have been appointed by TMO. So when assessing this, the inquiry should bear in mind that there was undoubtedly an extensive professional team in place, which already include numerous experienced contractors and CDM appointees. The inquiry had evidence from Artelia that it was not intending to fulfill the role, but in fact, it did not inform the TMO of this or of the need to appoint a project manager, even though part of its responsibility was to identify gaps in the professional team. Moreover, in meeting minutes, Artelia did refer to itself as project manager, and Philip Booth and Peter Blythe were referred to as project manager and assistant project manager, respectively. Although Claire Williams was a client project manager, this is wholly distinct from a project manager exercising a role in the design process. So we also invite you to consider whether Artelia was, through what it did on the project, a de facto project manager, including because the TMO regularly asked it for advice and to utilise its project management skills, and it did so. Moreover, Artelia was the employer's agent, and the roles of employer's agent and project manager were very close. So also assessing what, if any, were the effects of not appointing a project manager, it submitted the inquiry should keep in mind the confusion around who had design responsibilities, and I'll come on to that later, including the responsibility to ensure that all design was compliant with standards. The TMO submits there is no sound basis for thinking that an appointed project manager would have resolved this confusion. In fact, what was probably needed was a design matrix specifying who had design roles and on what specific matters. So another issue you considered was that of client design advisor, and this was considered at length by the inquiry. So significantly, neither the CDM regulations nor associated guidance and ACOP required a client design advisor to be appointed. And the TMO submits it was a very rare appointment to make at the time of the refurbishment. Whatever were the reasons for not appointing a separate client design advisor, it submitted there is no good evidence to suggest that the decision was purely motivated by financial concerns. As the inquiry knows, Artelia made a proposal to the TMO to perform the additional role of client design advisor for a fee of approximately £30,000, and the TMO declined its offer. The inquiry heard explanations from TMO witnesses as to why this was, including that the sum of £30,000 was relatively small when considering the overall cost of the project. Claire Williams set out her understanding of what the role entailed in an email to Artelia on the 29th of August 2014, where she said that whatever the role did involve, it did not relate to cladding. She, Claire Williams, was asked whether if a client design advisor had been appointed, they might have been able to alert the TMO to any mistake made by a contractor or a specialist subcontractor on the remaining design. And of course, so while this is a legitimate question to ask, it's ultimately speculative and fails to recognise that no one else noticed such mistakes or indeed alerted the TMO to them when they had responsibility to do this. So the assertion that TMO had the skill set to take on the role of client design advisor must be open to challenge. Certainly, Artelia did not explain who would check the drawings technically and who would determine if the drawings complied with ADB. Claire Williams' lack of technical knowledge must have been apparent to Artelia through her emails to them and Rydam about ACM. In fact, sir, it may be that a more pertinent question is not whether there should have been a client design advisor, but whether there should have been a specialist facade engineer. But you heard evidence from Jonathan Sakula, the expert in this, and he said that the need for such an appointment should have been raised with the TMO by Studio E, but it was not. So the last of the three roles that you considered was that of principal designer. And as you know, design responsibilities under the CDM regulations changed during the refurbishment of Grenfell Tower in 2015, meaning that a principal designer was required to be appointed by the 5th of October 2015. In fact, Artelia did not tell the TMO until very late in the day that it did not intend to take on the role of principal designer, when it certainly ought to have informed it earlier. In the event, Claire Williams took on the role after all others engaged on the project and other third parties approached refused to take it on. Her disappointment at being left to manage this was reflected aptly in an email between Simon Cash and Neil Reed of Artelia, dated the 27th of October 2015, where Artelia acknowledged its lack of professional closure. In fact, sir, Artelia offered to assist the TMO when taking on the role of principal designer. In any event, by the time Claire Williams took on the role, she was led to understand by the project team that the design was fundamentally complete and that she would be largely assisted by Artelia and Rydam in preparing and collating the health and safety file. So can I now turn to deal with the selection of the professional team and their roles and responsibilities? So the team engaged by the TMO in the pre-contract phase consisted of some 10 companies, and in the post-contract phase, 12 companies. In evidence, you heard from 33 witnesses whom the TMO dealt with either directly or indirectly. And so, to summarise, invidious as it may be, the inquiry heard a good deal of conflicting and inconsistent evidence from Studio E, Ryden, Harley, and Artelia about which of them had responsibility for important aspects of the design. Ryden says it expected, once appointed, that the designs already prepared by Studio E, Max Fordham and others were compliant with fire safety and building regulations. Harley said that when it was appointed, the selection of cladding materials was a fait accompli, as the materials had already been selected by Studio E, which, while true, leaves open the question of whether they ought to have done more to review them. Studio E said it was for the cladding specialist Harley to establish a fire safety strategy for its cladding design. Artelia, in turn, placed fault at the door of Ryden, saying that they should have identified any deficiencies in the fire strategy. So turning to deal with some of the performance of each of the individual contractors, starting with Max Fordham, and briefly here, Max Fordham was the building services engineering consultant retained by the TMO throughout the refurbishment project. In August 2012, it proposed the use of Celotex FR5000 for the rain screen cladding insulation, saying it could meet its target thermal performance value and was also thin enough to work within Studio E's proposed design dimensions. Paul Hyatt, your architectural expert, said that Max Fordham ought not to have proposed the FR5000. As being a PIR product, it did not comply with ADB. He said that a mineral wool insulation may have met the requirements of ADB if combined with sufficient cavity barriers. Studio E. Studio E was appointed by the TMO as lead consultant, lead designer, and architect. Although it's accepted that the inquiry will consider how the procurement rules were applied in Studio E's appointment, a significant driver in its appointment was a desire within RBKC to optimise the use of the CALP team, as it was recognised by all that to procure an architect would take several months, and there was a widespread and understandable desire to minimise any further delay. This notwithstanding, Studio E had shown its competence as architects on the large-scale CALP project for RBKC, where they had worked competently and efficiently. Witnesses from Studio E said that they considered that, despite not having worked on an overcladding high-rise building project before, it was not unreasonable for them to take on the Grenfell Tower refurbishment. Paul Hyatt agreed, saying it was reasonable for Studio E to be appointed as the architects, there having dealt previously and well with many other complex projects, despite their lack of familiarity with high-rise cladding projects. At the outset of the project, Studio E had envisaged using zinc for the cladding. ACM was first tabled for use in March 2013, when CEP met with Studio E after Alcoa, now Arconic, suggested there might be scope to switch from zinc to the cheaper ACM cladding option. Studio E had received similar advice when it started to work with Harley in 2013. Studio E therefore asked those tendering for the project in early 2014, including Ryden, to tender both for the original zinc cladding and to provide alternative prices for aluminium rain screen claddings, and ultimately Reynobond ACM was chosen. As Studio E specified the precise product to be used, they had a responsibility for ensuring that those products complied with the building regulations, as well as ADB, which gave a clear warning about the use of combustible materials in a cladding system. However, Studio E said it did not read the product brochure and did not consider using a cladding panel with a fire-resistant core. while they could have taken some comfort from the Class 0 rating, they should have looked beyond it also. If they'd been unable to appreciate or understand this themselves, they ought to have consulted the appointed fire engineer ex-over, which was retained on the project. Studio E didn't look at the CWCT guide, nor did it look at the BR document, Fire Performance of External Thermal Insulation for Walls of Multi-Storey Buildings. It was also unfamiliar with the Technical Guidance Note 18 and the BCA's guidance documents for the construction industry, including in June 2014, use of combustible cladding materials on residential buildings. Regarding insulation, Paul Hyatt, your expert, said that as Studio E was adopting the linear route to compliance with ADB2 and was specifying materials, they ought to have satisfied themselves that the materials were of limited combustibility, which of course they were not. So dealing with one point, in fact, Studio was never novated to Ryden, but was appointed by them, and its contract with Ryden was not finalised until the 3rd of February 2016. At REBA Stage D, it was contracted to understand and investigate the effect of the statutory standards and apply them to the design. At REBA Stage E, its role was to consult statutory authorities on developing and preparing technical designs and specifications, including for statutory standards and construction safety. Some quotes are pertinent in relation to Studio E, sir. Of Studio E, Paul Hyatt said, very serious problems arose simply because Studio E failed to produce the proper amount of design work that fell to their responsibility under the pre-novation stage appointment under which they were employed for a full and substantial service by KCTMO. He said that Studio E should have been capable of understanding and applying the guidance in ADB, and it failed to follow it and any other recognised route to compliance. He said a decision about which route to compliance with the functional requirement in B4 was being adopted should have been made before the tender process, and that they shouldn't have been relying on the input of a specialist cladding subcontractor to make that decision. So he didn't agree that Studio E's role was limited. Paul Hyatt didn't agree that Studio E's role was limited to reviewing Harley's drawings from the point of view of architectural intent, as had been suggested, as this was not, among other things, consistent with the Ryden Studio E deed of appointment. Turning now briefly to Exova. Exova was appointed by the TMO in mid-2012 to provide fire safety engineering services. It was said to be a top tier, a quotation, sir, fire safety engineering firm with extensive experience and an international practice. It was appointed under two separate instructions. The first to prepare a fire strategy for the building as it stood. The second to prepare a fire strategy in relation to the proposed refurbishment works. Despite producing several reports, none of Exova's reports mentions overcladding of the building. Dr. Lane in particular is highly critical of Exova, which he considers made some serious errors and omissions and instilled a false sense of security within the design team, and it is submitted within the TMO. Paul Hyatt is also critical of Exova for not drawing Studio E's attention to the inherent risks of ACMs on a high-rise building. Dealing now with Ryden. Key within the team of professionals was Ryden, which occupied the role of principal contractor within this design and build contract. So the role of principal contractor is defined again in the CDM regulations and associated code of practice, and its duties are extensive and include ensuring that the construction phase is properly planned, managed and monitored, and that there is competent site management. The TMO appointed Ryden as a design and build contractor in March 2014 after the tender process. Ryden had said it was a specialist in refurbishing affordable housing, including high-rise residential towers. As the inquiry noted, upon appointment, it took on an important design responsibility for the project, including developing the design and specification contained in the employer's requirements into something capable of being built. It appointed several specialist subcontractors, including Harley, which was itself particularly experienced in high-rise residential refurbishments, including ones that used similar cladding to Grenfell Tower, such as the Chalcott's Estate and Ferrier Point. In its opening statement, Ryden accepted that it was at the top of the supply chain at Grenfell Tower and had a contractual liability for the designers and specialists it engaged, as well as those it employed. And so clause 2.17.1 of the design and build contract with the TMO made Ryden fully responsible in all respects for the design of the works. In evidence, Simon Lawrence accepted that Ryden had a direct design responsibility to ensure the works complied with the relevant specifications, codes of practice and regulations. But despite this, it seems that no one within Ryden was checking that the designs were compliant with the building regulations. And there was, in fact, no in-house design expertise, no design manager was employed, and there was no design matrix which would have clarified design responsibilities. Paul Hyatt is particularly critical of Ryden for not having a tracker to monitor progress on this complex project. And he said the management of the project overall was chaotic. Ryden did not engage a fire consultant such as Exova, and none was ever integrated into the design and build team, even though minutes suggested a fire engineer was to be used after the tender stage. Ryden said that it typically did not engage fire consultants and had not engaged one even on previous high-rise overcladding projects such as the Chalcott's Estate. Paul Hyatt said he would have expected Ryden to retain a fire consultant on a design and build project of this size. Ryden was familiar in general terms only with ADB, but unfamiliar with the CWCT guidance and the standard for systematized building envelopes. Was also unfamiliar with the technical guidance note 18, was not aware of the guidance in ADB paragraph 12.7 that in a building of 18 metres and above, any insulation product used in the external wall construction had to be or should be of limited combustibility. So can I deal with one aspect of the evidence which relates to Ryden, and it's been referred to as the Lacanal moment. And I'll deal with this briefly if I may. So we accept that this is a significant matter, and we accept that you are likely to make a finding on whether the conversation Claire Williams and David Gibson said they had with Simon Lawrence from Ryden occurred. And of course, so the context is that Simon Lawrence denied reassuring Claire Williams about the cladding, but in fact said that if he had been asked, he would have provided reassurance, as indeed he did not consider the cladding to be unsafe. However, so there were at the very least two instances in which Ryden was asked for reassurance on the safety of the cladding. And while it's right that no email trail can be found supporting either the TMO or Ryden in reply, it seems likely it is submitted that matters would have progressed as they did without the question having been answered on either occasion. Turning now to Artelia. The inquiry will consider carefully the role played by Artelia, which was the employer's agent, quantity surveyor and CDMC, and whether it provided the TMO with the professional advice that was contractually bound to give. It is submitted that the inquiry should also consider whether the service it offered went beyond its contracted role. Artelia was engaged throughout the project. It was first engaged around about April 2012, was formally contracted from August 2012. Its CDMC role ended on the 5th of October 2015 when a new role of principal designer under the CDM 2015 regulations was created. In some paperwork, Artelia described itself as project manager, which is likely to have influenced the way that some companies, such as Studio E, understood its role. The main contractual documents governing Artelia's responsibility contained an appendix that said Artelia had design responsibility to make sure products used were not dangerous to health and safety and met applicable standards. So these were onerous responsibilities which Artelia plainly ought to have discharged. As CDMC, Artelia was required to advise the TMO about, inter alia, the competence of designers and contractors, including the principal contractor. It accepted that as CDMC, it was required to look at design risks and work with the design team on design risk assessments. So at no time did Artelia say it considered Studio E or Ryder were not competent to be able to perform their roles, or that the TMO should supplement its professional team with other advisors. Also, as CDMC, Artelia was expected to consider the reports issued by the fire safety consultant Exova, but despite this, it never said its reports, i.e. Exova's reports, failed to deal with the exterior wall and the cladding. So the inquiry will assess what Artelia said about its own role, but the TMO respectfully suggests that it sought to define its role and responsibilities too restrictively, and the TMO is entitled to place greater reliance on Artelia than it accepts. Moving now on to Harley. Harley was engaged as the envelope package specialist subcontractor by Ryden. They, principally through Osborne Berry, installed the cladding system, including Rainabond, PE, Celotex, and the fire barriers. Just excuse me for 1 second, sir. Can you shut that window? Sorry, sir, it's rather noisy here. We're just shutting a window.
Right.
As a bona fide cladding specialist, TMO placed great reliance on Harley to provide and use compliant products in the cladding of Grenfell Tower and to advise it if they were in any way unsafe. So, of course, it's a matter for the inquiry and your colleagues, but the TMO would submit that there's much about the evidence given by Harley witnesses which is troubling. What is apparent is that no one from Harley was willing to assume responsibility for the design of the facade or for the choice of the products used. Also, that despite their professed specialism, the quote was, "This is what we do," all seem to have limited understanding about the use of ACM and ADB and other guidance. Witnesses from the company accepted that Harley was taking on full responsibility for its design work and accepted that it had to assess the fire safety and compliance of each component in the system. Harley agreed it had an obligation to comply with all statutory requirements, including the building regulations, as well as the BRE document, Fire Performance of External Thermal Insulation for Walls of Multi-Storey Buildings, 2nd edition 2003, which provided that the system shall not be a fire risk at any stage of insulation, nor shall it constitute a fire hazard after completion if for any reason the insulation becomes exposed. Although it had onerous responsibilities in connection with the fire safety of components within the system, it seems that none of Harley's staff had been on product knowledge courses relating to ACM panels or on insulation to be used in a rain screen system, and some were unfamiliar with the curtains consulting specification and BR 135. Moreover, Harley did not understand the difference between the PE and FR core and never queried with anybody on the Grenfell Tower project whether FR, fire retardant, should be specified instead of PE. Instead, Harley said it relied on CEP and the manufacturers, particularly Rainabond, to warn them if the product wasn't suitable for the project. Regarding the RS 5000 insulation, Harley said that Studio E signed it off, so it used it without apparently making even a cursory examination of the fire performance of the materials. Had anyone at Harley read the certificate and the BRE report on which it was based, they would have realised that RS 5000 was not a material of limited combustibility. So despite accepting this, and the TMO would say inconsistent with this, Harley also sought to limit its duty to a responsibility to check that the products were compliant only to the best of its skill and ability, which of course should have been as a specialist, saying that Studio E was the facade concept designer. A good example of the unsatisfactory way in which Harley went about his work is that in August 2014, a freelance draftsman was brought in to act as project designer and to do many important drawings on the project. Despite Harley's design responsibilities, the freelance had not received any specific training on fire safety within facade design and had not worked on a high-rise residential overcladding project involving ACM. He had some awareness of important relevant guidance, but no formal training on the building regulations or ADB. He received no on-the-job training from Harley or any other party. He never met Studio E or building control, and no fire consultant or anyone from Harley ever checked his drawings. So he seemed to be unaware that there was a difference between National Class 0 and limited combustibility, and his understanding of the definition of limited combustibility was wrong. So I'm going to deal lastly, or possibly the penultimate topic in relation to cavity barriers, which we've identified as a discrete topic.
Mr. Agros, you're slipping down again, I'm afraid.
Oh, I'm so sorry, sir. It's when I move my screen.
That's it.
I do apologise.
No, don't worry. It's just that.
Is that better?
That's lovely. Thank you.
Yes. So the absence, wrong placement and type of cavity barriers around windows and in the external wall was undoubtedly a major cause of the spread of fire. The TMO thinks that the inquiry is unlikely to disagree with Paul Hyatt, who refers to multiple and serious errors in respect of the design of the cavity barriers at all stages. He said a cavity barrier strategy was needed before tender, and this should have formed the basis of the full plan's application to building control. He said he could find no evidence of a comprehensive design strategy with respect to the provision of cavity barriers. And rather than the piecemeal approach which occurred, the facade should have been looked at holistically and suitable drawings produced at the design and procurement stage by Studio E. He said there was a troubling lack of knowledge in both Ryden and Studio E about the need for cavity barriers, and a lack of mutual understanding about which party had the responsibility to specify, detail, and install them. In the event, cavity barriers were omitted from locations where ADB required them to be placed in a building of this type. To compound matters, it seems that, remarkably, building control had said that they were not even required. And when in September 2014, and March 2015, Studio E did seek some advice from Exova in respect of cavity barrier placement. Exova was of little assistance and did not even update their own reports. Harley could not explain why there was not a comprehensive strategy relating to cavity barriers during the Grenfell Tower project. It purported to have relied on Studio E, which it considered had the resources of a fire consultant available to it, and which it thought must have considered the cavity barrier design. Even then, there were departures from Studio E's drawings and those done by Harley, nor did the mock-up produced by Osborne Berry correspond with either drawings. Harley said it would have known it needed to put fire barriers, as it described them in, but wouldn't have known necessarily where they needed to go. This even though it understood that in the CWCT guidance for rain screen walls, ADB requires that cavity barriers are provided around window openings. It also said it relied on building control for the placement of cavity barriers. So the TMO submits that you should consider Harley's assertion that it was not responsible for placing cavity barriers around the window cavities very carefully. Also, consider carefully why, when Siderise identified on a Harley drawing that there was an obvious weak link for fire, Harley did not revert to Siderise or seek further advice from Studio E or building control. So Ryden said it relied on Harley and Studio E to advise on the appropriate design for the facade, including for cavity barriers, and on Harley to ensure that adequate fire barriers were placed. It also said it relied on consultation with building control. Astonishingly, again, the site manager from Ryden said he was specifically told that cavity barriers around the windows were not required. And so this topic was considered in some detail in Paul Hyatt's report, and he was asked about the TMO's role in relation to this important aspect of the project on a number of occasions. And while it's right to say that he was highly critical of corporate members of the TMO's professional team, he was not critical of the TMO, although specifically asked about it, which he says was entitled to expect that the designs produced by its professional team would be compliant with legislation. And so a last short section before I conclude, and this section is in relation to the role of building control and the clerk of works. I hope I haven't slipped down again. So the TMO invites the inquiry to look carefully at the roles played by building control and the clerk of works, and the extent to which its sign-off of the works, building control sign-off of the works, sign-off for the works as being compliant, serve to reinforce the TMO's belief that its professional team had delivered a compliant project. And so we accept, the TMO accepts that while building control can never have been expected to be a substitute for proper design or specification of suitable materials, as some parties have suggested it might, it certainly nevertheless had an important role in verifying whether those things had occurred. Building control inspected the site and signed off on the refurbishment work as compliant with the building regulations. RBKC has accepted that building control failed in several respects. It failed to ask for comprehensive details of the cladding system, including the crown. It failed to request an up-to-date version of the fire strategy for the refurbishment, and failed to identify that the installation materials or products using the cladding system were not of limited combustibility, and so not compliant with ADB. RBKC accepts that building control should not have issued a completion certificate as it did on the 7th of July 2016. So the inquiry may also consider whether Ryden did tell John Hoban of building control that the cladding system had been fitted to many buildings of similar height and construction throughout the UK, and that the cladding would comply with the standards set out in approved document B, and that the cladding panels were rated class 0 or above. Also, whether Ryden should have passed on details of the fire breaks following the note by John Rowan and Partners dated the 16th of June 2015, which stated, last building control site visit was the same as before, Friday the 15th of May. The only observation was that further details of the cladding fire breaks were required, Ryden to confirm if they have done this. And so lastly, in conclusion, in our oral submissions, so the TMO very much regrets any missed opportunities in preventing the Grenfell Tower fire from occurring. So the TMO does not want to abrogate responsibility and accepts that the inquiry will scrutinise its conduct and make findings about it. So what the TMO says that it discharged its duty as client under CDM 2007 and 2015 in this design and build contract. And although compliance with CDM will not be fully determinative of the issues the inquiry will examine, it is submitted that compliance with the primary regulations that govern the refurbishment of Grenfell Tower will be a reasonable indicator and barometer of the TMO's overall conduct. So as we have said before, the TMO invites the inquiry to benchmark its conduct against other social housing providers, also to view its conduct in the light of the widespread lack of understanding about the dangers of cladding and insulating high-rise buildings using certain products, which underpins the national cladding crisis. So a terrible fire with tragic consequences happened at Grenfell Tower, but it could equally have happened at any other building clad in the same or similar materials. In those circumstances, the TMO invites the inquiry to consider whether it is right to judge it as harshly as many have. The TMO did rely and was entitled to rely on the extensive professional team that was assessed pre and post contract, all of whom had their own duties under the CDM regulations. It's clear from the statements and oral evidence given before the inquiry that there was an unacceptable level of confusion among contractors and individuals working on the refurbishment, including as to where design responsibility lay and who bore responsibility for ensuring that materials used in the refurbishment were compliant with prevailing legislation, standards and guidance. Leaving aside for the moment the wider question of the extent to which manufacturers of these products sought to deceive the testing and certification body, the TMO invites the inquiry to consider whether it's reasonable or feasible for it to have seen through or ultimately untangled this confusion and deception. When the inquiry assesses this, the TMO submits it was entitled to rely on professional contractors and advisors who are regulated by their own professional bodies to understand and implement the detailed contractual arrangements that existed between them and the TMO. Whatever conclusion the inquiry reaches about the TMO's conduct, it should also, it is submitted, go on to consider whether the conduct identified was causative of the fire. This particularly because the intensive investigation conducted by the inquiry has shown that the causes of the Grenfell Tower are multiple, deep-rooted and systemic. And so that concludes the submissions on behalf of the TMO. And I'm sorry about the framing of my face. I moved my screen during the speech.
Well, Mr. Agaros, don't worry about that because we didn't lose sight of you and we could always hear you very clearly. So I don't think our understanding of what you were saying was at all affected. And thank you very much for your statement, which of course we found very helpful. Now, we're going to take our afternoon break at this point because we are expecting to hear one more statement this afternoon from Mr. Popat QC on behalf of Studio E. He was scheduled to appear at 3:45, but I think he may have been alerted to the fact that we would like to see him earlier if he can be free. And so, subject to his convenience, so to speak, we'll rise now and we'll resume at 3:25 and hope to see him then. Thank you very much. 3:25, please. Well, welcome back, everyone. The next statement is going to be made by Mr. Popat, Queen's Counsel, on behalf of Studio E. And I have Mr. Popat on my screen. Mr. Popat, can you see us and can you hear me?
So I can see and hear you all.
Good. Thank you very much. Well, if you're, it's good of you to make yourself available a bit earlier than I think you were scheduled to appear. But anyway, if you're ready to make your statement, we'd be pleased to hear it. Thank you.
Thanks, sir. Mr. Chairman, Mrs. Stefan, Mr. Atwell, it is 595 days since I appeared before the panel to deliver Studio E's opening statement for phase 2 of this public inquiry. In that opening, I began by explaining that the first thing Studio E wanted to say is how truly devastated it is that this horrific disaster occurred. And today, by this closing, the people who made up Studio E, the company, asked me to begin again by recording their deep and profound sorrow for the tragedy that befell the occupants of Grenfell Tower, all those involved in the rescue attempts following the fire, all those involved in other ways and whose lives were so tragically and seriously affected as the circles of terrible consequences rippled outwards from the events of the 14th of June 2017. Over these 595 days, the world has, of course, changed beyond all recognition. We've all seen harrowing stories of unimaginable suffering, and many of those listening may have been touched, in some cases, many times, by tragedy yet again. None of these awful events of the past 19 months, however, take away from the horrors of that shocking night in June 2017. Another, albeit comparatively insignificant, event that has occurred since I last appeared before you is that Studio E has gone into administration. I mention this not to garner any sympathy, but to explain to those who might not know that this small company's contribution to this inquiry, which was initially hampered by the limitations in funding for representation and legal assistance, has subsequently been affected by the cessation of its business. As a result, it was not legally represented for the phase 1 hearings of the inquiry, and following my brief opening statement, it was only represented for limited specific tasks during the phase 2 hearings. Its limited resources have also meant that it has instructed its legal advisors to review just a small minority of the additional documents, statements, expert reports, oral evidence of factual and expert witnesses, and the oral and written submissions provided by the other core participants. Yet, as I said on the previous occasion, and as I say again now, the people involved in this company have been concerned at all stages of these investigations to try and assist your inquiries and to be seen to be doing so. It wanted to engage, and notwithstanding the various constraints on its ability to do so, it did engage. Its people came and spoke to their witness statements and were questioned, in many instances vigorously so, over a number of days. But they sought to answer all the questions asked of them. And whilst its lawyers were not instructed to attend, many of those who were at Studio E at the time of Grenfell listened to and read much of the evidence provided to the inquiry. Further, they sought to assist the inquiry by identifying a number of questions which they properly considered should be asked of the architecture expert instructed by the inquiry. Those questions were formulated to try and elicit essential evidence that Studio E believed the inquiry needed to elicit to fulfill its terms of reference. Importantly, they also sought to assist the inquiry by making full written opening submissions with a substantial appendix, and they provided substantial written closing submissions. So the reason why Studio E did all of this, why they tried so hard to engage, to answer all questions asked of them, to ask questions of others, to set out their thoughts and arguments in writing. The reason why they did all of this was because they wanted to explain as fully and as clearly as possible the role they played in the project, and to clear up some apparent misconceptions and misunderstandings in the inquiry's provisional understanding, informed as that understanding was by the written evidence of its architectural expert. Studio E also did this because it too had questions, gaps in its understanding of what led to the events on that fateful night and why they happened, and to help the inquiry to discharge its function to identify any and all lessons that need to be learned, so that when buildings are constructed or refurbished in the future, the risk of a disaster like this ever happening again are eliminated insofar as possible. And so, sir, it is with great sadness that I now have to say that in many important respects, Studio E does not believe that the inquiry has yet properly explored all of the questions it needed to explore. Does not believe that the inquiry has yet elicited all of the evidence needed properly to learn all the lessons to be learned. And it does not believe that its role and the actions of the Studio E team have been properly and fully and fairly examined by the inquiry or its instructed expert. And so, sir, what I propose to do over the course of the next 40 minutes or so is begin first by summarising the conclusions that Studio E suggests can be reached on a fair appraisal of the evidence and an application of the proper test as to its role and performance on this refurbishment project. Secondly, to outline why Studio E believes that the inquiry's architectural expert evidence is deeply flawed and significantly inadequate. And finally, to identify why it considers that the approach of the inquiry has unfortunately resulted in it not receiving certain evidence which it, in Studio E's view, should have received, and the absence of which leaves crucial matters relating to the role of an architect unexplored or unanswered. So I will not lengthen the closing by providing references to each of the points and submissions that I'm about to make. Each of these points has been included in Studio E's written opening and closing submissions, and appropriate references have been provided in those documents at each stage. So let me begin with a summary of the salient points which Studio E contends are established by the evidence in relation to its role as the architect and the performance of that role on this project. And let me say straight away that with its own former directors and senior employees having examined the relevant documents as best they can, they having listened to the evidence of many others centrally involved in the project and experts instructed by the inquiry, and they having been vigorously questioned and having reflected on their own evidence, Studio E firmly believes that its staff were not incompetent, nor were they dishonest, and it strongly maintains that they discharged their obligations with reasonable care and skill, and in accordance with the practice of a responsible body of architects at that time. And it is crucial when making any assessment of Studio E's performance that its performance is not viewed with the benefit of hindsight, but rather within the confines of the knowledge and practices of responsible architects at the relevant time. When it is so viewed, Studio E contends that its understanding of its design responsibility and its knowledge base is typical of what would have been reasonably understood and known within the industry at the time, and which will be found to be underpinning hundreds, if not thousands, of similar completed projects across the UK. So in this section, I will list 10 points to substantiate the position I've just outlined. These are not the only points I could make, but in trying to manage the time we have for the closing, these are the 10 points we want to flag up now. Additional submissions and the detail behind these 10 points is set out in the written submissions, which I'm confident will be carefully considered by the inquiry team. So, sir, with that, let me make my point one, which is that the relevant regulatory system was not fit for purpose. This was the conclusion of the interim report in Dame Judith Hackett's review of December 2017. The Royal Institute of British Architects' submission to the review agreed and said, I quote, "The current building, house and fire safety legislation, associated guidance and compliance routes are ambiguous and open to widely varying interpretation." Appendix F of Dr. Lane's 2018 report to the inquiry said the system contained areas, quote, "of confusion, disagreement and loose interpretation." And, she said, had permitted the routine use of what are now considered to be unsafe cladding materials on buildings for many years. The fundamental relevant problem with the system as it pertains to the issues for this inquiry and the fire is that in simple terms, it permitted the use of combustible and highly flammable materials. Studio E contends that ADB2 allowed combustible material on the external walls of high-rise buildings so long as it achieved a Class 0 classification. And Studio E understands that BBA certificates for Renault Bond, Aluca Bond and Vulcan at the relevant time verified that ACM cladding with a combustible polyethylene achieved a Class 0 classification. Indeed, we note that BBA revised certificates for some of these materials just 7 weeks after the Grenfell fire. Further evidence that ACM with a combustible core was regarded as compliant prior to the fire is the fact that the government have had to amend the building regulations and ADB2 guidance in order to ban the use of combustible material. So we contend that any assessment of Studio E's performance and its exercise of reasonable care and skill must be considered in that context, the context of that regulatory system. And that is the basis of my second point. These flaws and weaknesses in the system allow the widespread use of unsafe cladding materials on high-rise buildings. In relation to this point, we note that currently the MHCLG has identified 469 buildings with ACM cladding systems unlikely to meet the building regulations, 257 of which are in London. There are also estimated to be a further 1,700 buildings with combustible non-ACM cladding above 18 metres, which required remediating from the Building Safety Fund. These circa 2,000 buildings represent approximately 16% of the estimated 12,500 high-rise residential multi-occupied buildings of 18 metres or more than 6 stories in height. This is a significant percentage of buildings which have similar characteristics to those of Grenfell Tower. The significant volume of tall buildings with materially similar cladding systems unfortunately demonstrates by itself that a high-rise tower clad with combustible cladding as at Grenfell does not by itself evidence a departure from the norm. It certainly cannot be described as an outlier or plainly unacceptable to the people and bodies responsible for constructing or refurbishing such towers, or those responsible for designing them, or those responsible for checking them. So point 3 is that others knew of the problems and exacerbated them. In this regard, certain product manufacturers are now widely reported to have produced materials and testing data which had the effect of misleading designers and other parties, including building control officers, approved inspectors, and on occasions, fire engineers, BRE, BBA, and other testing bodies, to consider that their products were safe. The certificates obtained from industry bodies such as the BBA, BRE, LABC, and NHBC, on which professionals in the industry reasonably relied, are now known to not accurately reflect the risk posed by certain products. These problems and difficulties in the system created an industry in which certain materials were routinely marketed, certified, specified, reviewed, and signed off as compliant with the regulatory regime. As a result, the industry gained misplaced confidence from the continued and widespread use of them. So, point 4 is that the knowledge of the inadequacies in the systems was not held by Studio E and could not be expected to be held by a reasonable body of architects at the time. The sort of problems were not known by the reasonable architect. Indeed, misleading tests and certificates would have the impact of further misleading designers to consider that these products were safe. Moreover, the test by which the conformity of a product to the criteria within ADV2 or BR135 are of a scientific, not an architectural nature. A reasonably competent architect would not be expected to have an understanding of what these tests entail. Instead, the architect would satisfy itself that the products had met the necessary criteria by reference to and reliance upon documents which confirm that compliance. For instance, where the LABC stated that K15 may be considered to be a material of limited combustibility, a reasonably competent architect would not consider itself competent to challenge such assertion, nor would there be any good reason at that time for it to do so. Further, Studio E itself did not have any actual knowledge at the time of the project that the products used on the tower were unsafe, and it could not reasonably have been expected to know that they were not safe. So in this regard, it is noteworthy that Harley and Ryden had previous experience of using the same or similar cladding materials, that Studio E was aware that similar products had been used on high-rise residential buildings for many years. Indeed, it was referred to one such building that had been refurbished by Harley and Ryden with ACM to show how the material could be used. Studio E also reasonably understood that a facade specialist would be responsible for satisfying compliance to the building regulations. So by way of point 5, we seek to emphasise Studio E's design role and contend that that role was generally limited. It's against the background of the previous points that I've made that it's important to have a proper understanding of Studio E's actual role on this project. It is only then that an assessment of its performance can fairly be conducted. For example, at the stage of preparation of the employer's requirements, Studio E's role was to prepare design information for the purpose of allowing the works to be put out to tender. It was known at the time and always envisaged that the actual design of the cladding would be carried out by the successful main contractors and their appointed specialist subcontractor. To ensure that the design information in the employer's requirements was of sufficient detail to enable an effective tendering process, Studio E consulted widely with a number of manufacturers, fabricators, and installers, including Harley, and provided them with sufficient details and information to identify the necessary requirements for the tower. Studio E also consulted with the appointed fire engineer, who, by its report, advised that, quotes, "It is considered that the proposed changes will have no adverse effect on the building in relation to external fire spread, but this will be confirmed by an analysis in a future issue of this report." Throughout this wide preparatory and consultation process, at no point was Studio E alerted to any cause for concern regarding the tender design information in the employer's requirements. Post-contract, Studio E was appointed by Ryden to provide architectural services during the construction stage of the project. Ryden was the design and build contractor that held itself out as having a speciality in refurbishing affordable housing, including high-rise residential towers. It is crucially important to understand that upon appointment, Ryden took on design responsibility for the project. Ryden was responsible for the development of the design and specification contained in the employee's requirements and to turn it into something that could be built. Ryden appointed various specialist subcontractors who were responsible for their package of works on the project, such as the cladding subcontractors Harley. Harley was particularly experienced in high-rise residential refurbishments and, as I've already mentioned, had worked with Ryden before on other projects which used similar systems to that used on the Grenfell project. Studio E's role during the post-contract period included coordinating the detail design of others, including the engineers and specialist subcontractors, liaising with planning and building control to achieve statutory approvals, and responding to site inquiries. In coordinating the detail design, Studio E commented on drawings prepared by others, including Harley. This was from the view of maintaining the architectural intent established at the planning and tender stages, which covered aspects such as siting, spatial arrangements, amenity tolerances, appearance, proportions, colours, or finishes of the products. When Studio E spotted a clear and obvious error when reviewing drawings for consistency with architectural intent, it would raise a comment for the designers to address. Studio E did not review these drawings for any purpose above and beyond their consistency with architectural intent. The subcontract package for which Harley was responsible was specialist in nature, and Studio E could not identify technical errors in the designs and/or specifications of these specialist disciplines. Ryden was responsible for approving Harley's designs for the cladding facade. It was for Ryden and its specialist contractors to determine whether the materials proposed for the cladding and its fixtures were suitable and met the requirements as relevant and as set out in the employer's requirements. If there had been an obvious issue of non-compliance, it could be said that the reasonably competent architect should identify that. But the panel and insulation were marketed as suitable for their intended use, and none of the specialist subcontractor, main contractor, fire engineer, or building control deemed there to be an issue, let alone an issue so manifest that the reasonably competent architect should have raised concerns. So point 6 is to consider Studio E's role in the building control process. Studio E was responsible for coordinating the building control approvals process. However, building control had advised Studio E that it wanted to control the provision of information regarding the works, such that it would request the specific information it considered it required, starting with a basic set of design information and moving on from there. As a result of the process required by building control, documents and drawings were provided in stages, and building control would then ask for any additional drawings and information as the refurbishment works progressed, and would satisfy itself of any particular issues during the course of its site visits. Studio E provided both its own information and information provided by others to building control for its consideration. Studio E also understands that there was direct contact between building control and others on the project that did not involve Studio E. And ultimately, building control certified the works as compliant. So by way of point 7, I address Studio E's role specifically in relation to fire safety. And with regard specifically to fire safety, remind the panel that at the initial meeting with KCTMO, it was Studio E who raised the possibility that specialist fire safety advice may be required. This recommendation was accepted by the TMO, and Studio E was instructed by it to approach Exova to provide a quote for the provision of specialist fire consultancy services. And the TMO thereafter engaged Exova as its fire engineer. Save for minor matters, Exova did not raise any queries or concerns about the brief to overclad the tower or the compliance of the cladding and its components with Part B4 of the building regulations. Had it done so, Studio E would have ensured that they were resolved in due course with building control. And as for the Celotex FR5000 product, this was first specified by Max Fordham, the specialist M&E engineer, to meet their performance requirements. Studio E sent Exova its Stage C report, which contained details of the Celotex product on the 31st of October 2012. Exova was therefore aware that the FR5000 product had been specified for the project from an early stage. Yet Studio E is not aware that Exova gave any advice or warning regarding the use of Celotex FR5000 on an 18-metre plus building with a story above 18 metres at any stage of the project. It is submitted, therefore clear that when including the Celotex product advised by Max Fordham, Studio E relied on the advice of Max Fordham and Exova with regard to its suitability, including with regard to fire safety. In this regard, Studio E also relied on trade literature and extensive use of the material on previous completed projects, all indicating that the product was securing approval from building controls across the UK over many years. And after the works had been tendered, Ryden had primary design responsibility for the rain screen cladding facade. The cladding package was expressly designated as a contractor's design element in the employer's requirements. It was for Ryden and its appointed specialist subcontractor to carry out the detailed designs and to ensure that their designs complied with building regulations. Indeed, in the design warranty, it was Harley, not Studio E, that was obliged to sign off the overclad, and it is Harley that held itself out as a self-professed expert in cladding application. It was Harley that changed the insulation specification from the FR5000 to the Celotex RS5000 in September 2014, and they did so without reference to Studio E. They also changed the panel specification from zinc to ACM. And Harley did not seek Studio E's advice regarding these changes in specification and appeared to have had no concerns regarding the use of the RS5000 or ACM. Ultimately, of course, I've already mentioned, building control approved the rain screen cladding facade, including the use of Celotex, as compliant with the regulations. So at point 8, I just want to mention Studio E's role in relation to cavity barriers in terms of window openings, compartment walls and compartment floors. Studio E's approach to cavity barriers, developed in consultation with others in the employer's requirement, was set out in its drawing in section P10/435. The drawing shows that the cavity barrier strategy was based on preventing fire from travelling from one compartment to another via the cavity. The compartments lined up with the bays. As such, this drawing shows cavity barriers along all compartment lines in order to prevent a fire breaching the compartment line. This, in principle, design for the cavity barriers was, it submitted, reasonable. Any further development of the design was to take place during detailed design development following the appointment of Ryden and Harley, who were then responsible for ensuring compliance with the building regulations. In the exercise of its coordination role thereafter, Studio E liaised with the different parties as required to coordinate the approach to cavity barriers. As a result of Studio E's coordination of building control approval, the cavity barrier designs of Harley were agreed by building control. Studio E also specifically sought the input of the specialist fire engineer Exovo regarding the cavity barrier strategy. In short, therefore, in relation to these barriers, the strategy and principle of installing cavity barriers in line with the compartment edge was reasonable and consistent with industry practice over a wide range of construction types. It was for Ryden and its specialist subcontractor to provide the detailed designs of the cavity barrier strategy and to ensure that it complied with building regulations. Studio E liaised with Hardy, Exovo, Siderise and Building Control to coordinate Building Control's approval of Hardy's designs. And in any event, and unfortunately, as stated in section 10 of Dr. Lane's report to the inquiry, due to the presence of ACM, the cavity barriers would have made negligible difference to the spread of fire regardless of where they were located. So point 9, Studio E properly consulted and took advice from appropriate specialists. Throughout its role on the project and in order to obtain information where others had greater or more specific expertise, which was outside the expertise of a reasonably competent architect, Studio E consulted with those specialists wherever necessary. Studio E relied on the advice of those appointed specialists and suppliers that the products being considered were suitable for the intended purpose. The Studio E considers it was reasonable and appropriate for it to do so. Had any specialist had any concerns or raised any queries on any of these issues, Studio E would have acted on them. And it would, it is submitted, be self-evident to any manufacturer, fabricator and or installer that its products would need to comply with the relevant regulatory regime. None of those entities contacted by Studio E raised any queries or concerns regarding the brief to overclad the tower or the compliance of the cladding and its components with Part B4 of the building regulations. Similarly, Building Control did not raise any queries or concerns regarding the brief to overclad the tower or the compliance of the cladding with Part B4 of the regulations. Again, had it done so, Studio E would have worked to resolve those concerns. And so all of this leads to my final point in this section, point 10, and that is that Studio E exercised the reasonable care and skill required and expected of an architect in its position. We make that submission for all the reasons set out in the written opening and closing submissions provided by Studio E, by its oral opening and by today's closing, and having had regard to much of what has been said by others. Studio E respectfully but firmly says that it did discharge the duties it owed in its role as an architect on this project. Its performance can only be assessed and judged once proper consideration is given to the standards of the industry at the time, the regulatory system governing construction and refurbishment, and in particular cladding of high-rise buildings. It's only then that Studio E's role on this project, which also needs to be considered in the context of the terms of its engagement and its involvement and actions of all those involved on the project, can be properly evaluated. And so when that is done, and its actions are not viewed through the lens of hindsight, it can be seen that Studio E acted in accordance with the standards of a responsible body of architects at the time. The former Studio employees are devastated that in spite of this, in spite of the way it carried out its duties, such a horrendous tragedy could happen. They are devastated for all those affected directly by events at Grenfell, and also on behalf of all those many others who now find themselves in buildings deemed unsafe. And also deeply shocked to discover that there are so many other affected buildings. I will not repeat all that I've already said in my previous points, but I will just collate the important observations we invite you to draw in relation to the issue of cladding. This is an important example of Studio E's performance as compared to that of others involved in the project. And in this regard, we say the cladding was designed by Harley, not Studio E. Harley, the specialist subcontractor that designed the cladding, raised no concerns about its designs. The project-appointed fire engineer with full knowledge of the products raised no concerns about Harley's designs. Project-appointed building control with full knowledge of the product raised no concerns about Harley's designs. The project-appointed main contractor with full knowledge of the products raised no concerns about Harley's designs. The panel was marketed as Class 0, and the insulation was expressly stated to be suitable for use above 18 metres. And there was nothing to alert Studio E to a problem with Harley's designs. Indeed, there had been a sustained campaign by product manufacturers to convince the construction industry that they were safe for use on buildings like Grenfell. These conclusions in relation to the cladding are just an example of one aspect, albeit for present purposes, a crucial aspect of the project. Similar conclusions about knowledge can be reached in respect of many other issues that arise, and the inquiry is invited to consider in relation to any of these issues, for example, fire safety, cavity barriers, window openings, etc., 3 questions. Who knew of the problem at the relevant time? Who didn't know but should have known? And who didn't know and could not reasonably have been expected to know? In every instance those questions are asked, Studio E should be assessed as falling on the right side of the dividing line. So with that, I move to my section 2 as part of this closing. And that relates to the evidence of Mr. Hyatt, the architectural expert instructed by the inquiry. So the evidence provided by Mr. Hyatt is in Studio E's submission, subject to numerous and significant flaws. Let me start with his lack of relevant expertise and experience. The evidence provided by Mr. Hyatt to the inquiry to date, including the Hyatt report and Mr. Hyatt's supplemental report, gave rise to significant concerns that he does not have the requisite experience as an architect to advise the inquiry on the issues relevant to its terms of reference. These concerns were set out in detail in Studio E's previous submissions. However, it would seem those concerns were not accepted because, of course, Mr. Hyatt continues to be the sole architectural expert instructed by the inquiry. But his oral evidence only compounded the concerns already expressed by Studio E. Mr. Hyatt confirmed that he has never been involved in an overcladding scheme, never applied Section 9 or Section 12 of ADB2 in practice, was not aware prior to his work for the inquiry of what are now known as the different routes to compliance with functional requirement B4 of the building regulations, that he was not aware prior to his work for the inquiry of the BCA Technical Guidance Note 18, either in its first version or revision 1 published a year later, that he had never completed a specification using the NBS software used by Studio E on the project. For the last decade and a half of his career had not been at the pit face of projects, and he did not appear to have any significant knowledge or understanding of design and build procurement. Mr. Hyatt has therefore never personally dealt with the very issues on which he was asked to provide expert evidence. It appears that Mr. Hyatt's one and only experience of cladding is on a new build stadium in Perth, Australia. His oral evidence on this project was short and, we contend, vague. However, it was clear that this was a very different type of building to an existing high-rise residential tower as at Grenfell. It was situated in a different jurisdiction with different regulations, legislation, guidance, and industry practice to that which applied to Grenfell. In any event, it remains that Mr. Hyatt's experience of cladding is, at most, limited to a single project, which, for reasons already set out, bears little relevance to Grenfell. Mr. Hyatt cannot, therefore, it is submitted, express a valid expert opinion on these issues, and his evidence should carry no or minimal evidential weight. His lack of expertise, which may be a consequence of his lack of experience in the matters on which he was asked to opine, was also demonstrated by various other aspects of his evidence. His flawed understanding of design and build contracts, his misunderstandings of tender specifications on design and build contracts, the evidence he gave regarding appointments, his lack of understanding about the division of responsibilities on a design and build project, his lack of understanding about ADB2, the route to compliance with the building regulations and the cavity barrier strategy. Also, and again, unfortunately, he showed a lack of understanding about the evidence he had apparently reviewed in order to prepare his report. And again, by way of just a single example, he referred to a helpful grid, as he described it, contained in Dr. Lane's report, without realising that the grid was taken from Studio E's drawings. This lack of understanding of the evidence is also shown by the view that Studio E were driving the overclad of the tower, when the evidence shows clearly that they were not. And also, the majority of the responsibilities that Mr. Hyatt ascribed to the architect, in fact, rested with parties other than Studio E on the project. And the approach set out by Mr. Hyatt in many places in his written evidence and his oral evidence was predicated on an assumption that Studio E was to prepare all of the detailed design and or dictate what the detailed design should be. This goes against the inherent philosophy of a design and build procurement which applied to this project, in which the detailed design is developed by the design and build contractor with experts in the industry. Further, Mr. Hyatt has not examined the approach of other architects on the other 436 tall buildings identified by MHCLG as having ACM above 18 metres or being otherwise non-compliant with building regulations. It follows that Mr. Hyatt cannot opine on the standards reasonably to be expected of an architect on commissions of the type, complexity and scale as Grenfell Tower. He cannot rely upon his own personal experience of similar projects because he does not have any such experience, and he has chosen not to investigate projects of a similar type. Likewise, Mr. Hyatt cannot sensibly comment on the reasonableness of the choice of materials or construction techniques at the tower without an understanding of whether, and if so why, a responsible body of architects involved in those other projects exercised reasonable care and skill, and yet the same or similar materials came to be used. Separately, Studio E notes that similar concerns could be raised regarding the inquiry's appointed cladding expert, Mr. Sekula. Mr. Sekula confirmed in his oral evidence that he has no experience of overcladding projects on buildings over 18 metres in the preceding 18 years. No experience of specifying or using ACM panels with a PE core, and he is, quote, not really so much involved in that part of the industry. This increases the risk of any findings made by the inquiry in reliance on either Mr. Hyatt's or Mr. Sekula's evidence being ill-founded. So I say no more about the topic of expert evidence. We have set out a lot of material in the written opening and closing submissions, and we urge a careful examination of the points made there. But I turn now, if I may, to section 3 the final section of this closing, and that relates to issues with the structure of the evidence of the inquiry. Time does not permit any lengthy examination of these points in the oral closing. We've set out a number of detailed concerns and observations about the approach of the inquiry to the architectural issues, and specifically to the questioning of witnesses by counsel to the inquiry. As I say, I do not repeat those matters here, but I do identify as headline points just a few matters. And I make these observations very much in sorrow, not in anger. But I do draw attention to the impression, at least, that was received by Studio E, that unfortunately counsel to the inquiry may have approached questioning of relevant witnesses, including Studio E witnesses, with a preconceived idea that Studio E had failed properly to discharge its obligations. That led to, for example, persistent questioning on certain topics where the witnesses' initial answers did not accord with that apparently held preconceived view. On the other hand, matters which should have been explored with witnesses in light of answers they had given were not explored if the answer given was consistent with or supportive of that apparently preconceived view. Matters set out in the witness statements of Studio E witnesses were not put to other witnesses to advance Studio E's explanation of events or to correct a misunderstanding apparent in the witnesses' evidence. And many of the points and questions Studio E had invited counsel to the inquiry to put to Mr. Hyatt were simply not advanced. The problems caused by the questioning of witnesses, and Mr. Hyatt in particular, are exacerbated because it is, of course, the case that it is not possible for Studio E to adduce independent expert evidence of its own, as it would, of course, in other types of proceedings, when the experts would have the opportunity to discuss their respective positions, produce a joint statement, and then for the experts to give oral evidence and be cross-examined. In the absence of that scrutiny, Studio E have not had the opportunities to address the concerns that they have about Mr. Hyatt's evidence. So more generally, in relation to the structure of the inquiry, we do note that the government evidence regarding the regulatory regime is not to be given until Module 6. And we do ask in those circumstances how, particularly Mr. Hyatt, can fulfil his instructions without having heard that crucially important evidence. And the structure of the inquiry risks, therefore, decisions taken by Studio E being viewed as the exception when evidence suggests that they were consistent with industry practice. We have suggested that a potential way forward would be for the other high-rise buildings noted to have similar materials or designs which were referred to by Module 2 witnesses to be analysed so that they can provide an insight into industry practice at the time of the works. Studio E considers that this may be of some comfort for those living in potentially affected towers up and down the country. As I've already said, there are over 2,000 buildings with the same or similar materials to those used on Grenfell Tower. Some of those buildings form part of the evidence already presented to the inquiry and can therefore be scrutinised as part of the inquiry's proceedings. And information on others can be obtained either from public pleadings in the business and property courts or by way of an information request from the MHCLG. So alternatively, the inquiry could seek to appoint another architectural expert who has the requisite experience to advise on these matters, or could invite architectural practices and professionals to submit their views to a public consultation. Such a consultation could, of course, be expanded to the wider construction industry. In short, Studio E does not consider that the inquiry can fulfil its terms of reference or can make findings on Studio E's performance of its obligations if it does not broaden its analysis of the industry at the time of the works through the suggested or other appropriate means. Studio E, of course, remains open to discussing this further with the inquiry, should it be invited to do so. So that concludes what I want to say on behalf of Studio E, save for my final remarks. And these are that, having been retrospectively examined and considered, Studio E does believe that the relevant regulatory system was not fit for purpose and appears to have permitted the routine use of unsafe cladding materials on buildings for many years. Product manufacturers produced materials and testing data which had the effect of misleading designers to consider that their products were safe. At the time of the project, Studio E did not have any knowledge that the products used on the tower were unsafe, and there was no information available to it, or indeed to other architects, designers, and building control, which would have reasonably alerted it to any lack of safety. And whilst it will continue to examine this question and will listen to, and where it should, it will accept any criticisms levelled against it. From its understanding of the industry and awareness of the volume of tall buildings at the time with materially similar external surfaces, Studio E considers that it acted as would be expected of a reasonably competent architect in its position. It is nonetheless devastating to it that, notwithstanding the tragedy at Grenfell occurred, and that so many other people in so many high-rise buildings are even now living in fear of buildings deemed unsafe. So thank you for giving me the opportunity to make these remarks, and I conclude on behalf of Studio E once again by expressing the heartfelt condolences and sympathies of all those associated with that company. So thank you.
Well, thank you very much, Mr. Popat. That, I think, concludes the statements that we expect to hear this afternoon. We shall hear further closing statements tomorrow, and that we shall do at 10 o'clock tomorrow morning. Thank you very much. 10 o'clock tomorrow, please.